all of us in the arbitration field done something. At least I had no idea that arbitration awards are not recognized at all and was treated as rough justice. But that's why we're all here, to learn something new. Our next keynote speaker is Justice NARIMAN, who of course needs no introduction, and we've all known him both at the bar and the bench as an outstanding lawyer. And my only claim to fame is we actually went to the same high school. So with that, I'll say Justice NARIMAN.
Mr. Gary Vaughan, Mrs. Pallavi Shroff, fellow cathedralite, hero, my beloved parents, ladies and gentlemen. Thank you, Mr. Bond, for your extremely illuminating analysis of the right to arbitrate. I was wondering what I'd speak about this evening. So you've given me so much fodder that, I don't know where to begin. But let's begin at the beginning. You took us back to the year 1792. I propose taking you back to the year 1689. And I'll tell you why in a minute. But one other very interesting thing about Justice Joseph's story. He was a genius. He was made a US Supreme Court judge when he was only 32. And it's a sobering thought that by 32, Alexander, Shankaracharya and Franz Schubert were dead. But this man, according to the greatest Chief Justice perhaps in any jurisdiction, John Marshall, was considered so learned that he'd say Brother Story knew everything from the 12 tables downwards. And I'm surprised that Brother Story ultimately came to the conclusion that he came to. But I must tell you that in this country, we were a little more progressive. In 1872, which is the year of our Contract Act, which is about 30 years after Brother Story's judgment, we in our section 28 already had an exception, because agreements in restraint of legal proceedings are void. Exception 1, the right to arbitrate. So we were progressive. And we were progressive because basically we took on the mantle of English law. Now in England, obviously something very different had happened. The right to arbitrate was considered as something private and outside the courts of the King's Bench. This continued till the year 1688. Now why is 1688 significant? In English history, it's extremely significant for two reasons. One, the first Dutch ruler of England ever came and was called to rule, William III. Now he happened to be called because he was Protestant, no other reason. And James II was a Catholic king who had just been expelled in the Glorious Revolution, so-called, because there wasn't a single shot fired. The king had to go down the tower and quietly go down a boat, in a boat by himself down the Thames, where he dropped the Great Seal of the Lord Chancellor into the river and pushed off to his cousin Louis XIV in France. Now, William, therefore, came at a period when Parliament thought that it had great bargaining strength, because he ruled jointly with his cousin, Mary, who happened to be James II's Protestant daughter. So Parliament decided that they would have the first real Bill of Rights of 1689. Various expressions well known to us, such as the 8th Amendment expression, cruel and unusual punishment, all come from this Bill of Rights. And interestingly enough, another burning topic of the day, over here at least, is appointment of judges. And that Bill of Rights sought for the first time to make an inroad into the doctrine of the king's pleasure so far as appointment of judges is concerned. Because till then, the moment a monarch left, the next monarch could either wholesale do away with all the judges, continue then, put whoever he wanted, and so on and so forth. But Parliament for the first time asked the king to sign a Bill of Rights which guaranteed both tenure and salary. the king refused to do so for another reason. He refused to do so only because he said, you are making me sign something which is already part of your law. This is not part of your law. So I refused to sign it. And they had to wait till the reign of his sister-in-law, Queen Anne, when the Act of Settlement was passed in 1701, to ultimately secure the tenure and the salary of judges. But all this is by the way. Why we go back to King William III is because for the first time, Parliament by a statute stated that a private tribunal would now be controlled by the courts of the King's Bench. And the only ground for setting aside a private tribunal's award, as it was called in those days, was the ground of bribery or fraud. There was no other ground. We now move on till the year 1802, which is a long shot from 1688, 100 years plus. And we then come to another decision of the Court of King's Bench, Kent versus Elstow. And in Kent's case, for the first time, what we know in India as the Chamse Bara principle was applied. Namely, that if an award happened to be or happened to have on its face an error of law apparent, then on that ground also it would be set aside. Now, this principle was borrowed from administrative law, interestingly enough. And as we are told by Lord Denning in the Northumberland case in 1952, administrative law itself did not use this principle for over 100 years. So it was a borrowed principle. It came into the law of arbitration. Administrative law went back to the classic jurisdictional aspect of the writ of certiorari, and errors of law apparent were not revived until 1952 in England. We in India were governed by this principle even before the Privy Council's decision in Jivaraj Ballu versus Chamse Bara, which is why it's called the Chamse Bara principle, a decision of the year 1923. And this principle is so ingrained in our minds that it continued in our 1940 Act, even though it wasn't expressly stated there, and continued to be applied by all the courts. The stage is now set for the new 1996 Act. But just before that, we had, as you said, the New York Convention of 1958. We were one of the early signatories, and we had a Foreign Awards Recognition Act of 1961. Now, we bodily lifted the grounds in Article 5 of the Convention and made it part of Section 7 of that 1961 statute. And the basic thing that confronted our courts when foreign awards had to pass muster in India for recognition and enforcement was the public policy exception. Now, in India, lawyers are familiar with the phrase public policy as an aspect only of contract law. This occurs in Section 23 of our Contract Act. And by the time the Foreign Awards Act came in, we had a decision of the Supreme Court, Kherulal Parakh in 1959, which stated that at least in contract law, the heads of public policy were closed. You had some 10 recognized heads. It was described otherwise as an unruly horse, etc. And the judges in India were told in 1959 that at least so far as the law of contract is concerned, this head can no longer be expanded. It contained within it those 10 particular topics, such as trading with the enemy, champerty maintenance, etc. And this continued right till the 1980s, when we had a very illuminating judgment of one of our greatest judges, Justice Madan. He was a Parsi priest like me. And he wrote one of the most brilliant judgments in the Central Inland Waterways case, a very well-known judgment. where he referred copiously to and extensively to English law and arrived at the exactly opposite conclusion that given our constitutional fundamental rights, guarantees, etc., the heads of public policy are never closed and must be opened when justice so demands. Now, this is how contract law stood at the time that public policy now crept into private international law through the Foreign Awards Act. And the first time we had ever to confront this problem in the private international law scenario was in the Renusagar judgment, which is the judgment of our court. It delivered in 1994, 2 years before this act came into force. And there again, Justice Agarwal, who wrote the judgment, being a good civil lawyer, began with the Contract Act position, because we were obsessed by that somehow. And then said that because there are two views, the Gherulal Parak view, 59 view, and the 1986 view, you can construe this either narrowly or broadly. And in the context of private international law, given the New York Convention, given the fact that judicial interference should be minimal, etc., we will adopt what we call the narrow view. Now, the narrow view, again taken from a number of English judgments, comprised three basic things. The first was described as the fundamental policy of Indian law, as vague as you can get. The second was described as against the interests of India. And the third, this being a narrow view, was the award being contrary to justice or morality. Now, justice takes in pretty much everything, and morality again takes in pretty much everything. It's almost as if you are in a complete equities jurisdiction, not bound by law, and the Chancellor's foot in every case can decide that this award is contrary to justice, that award is contrary to morality. But anyway, this is what Renusagar laid down in 1994. The present act comes into force in 1996, does away with the Domestic Act of 1940, the Foreign Awards Act of 1961, the Geneva Convention Act of 1937, and brings arbitration within one particular act and divides it into parts. Part 1 deals with the domestic scenario, Part 2 deals with the New York Convention scenario, Part 3 Geneva Convention, Part 4 miscellaneous, etc. Now, interestingly enough, the draftsman of this particular statute again bodily lifted Article 5 of the New York Convention and made it Section 48, which occurs in Part 2, which deals with recognition and enforcement of foreign awards. Strangely enough, he also lifted this and put it into Section 34 in Part 1, barring one particular ground, which would apply only to foreign awards, namely that they have to be both binding in the country in which they were delivered and they should not have been set aside in that country. So barring that one ground, the entire Article 5 of the New York Convention was picked up and put into our Part 1, which deals with challenges to domestic arbitrations. Nobody had quite thought that international arbitrations which took place in India would also be governed by Section 34. That I don't think was present at the forefront at that time. So that could not possibly have been a reason for picking up the New York Convention and suddenly making it exactly the same so far as domestic awards are concerned. But anyway, that was done. And we therefore started off with, let us put it this way, a Renusagar regime so far as Section 48 was concerned, that is the foreign award part. Whereas I told you we had these two at least extremely vague expressions, fundamental policy of Indian law and justice and morality. And all hell could have broken loose depending on which judge felt which way. Now, Renusagar itself made a distinction between errors of law, which were apparent, that is the Chamse Bara principle, and the fundamental policy of Indian law. And it did it this way, it did it textually. It went by the old 1937 Geneva Convention Enforcement Act here, which had a similar provision to Article 5. The difference being that public policy of India was followed by all laws of India. So the court reasoned, obviously, if it is contrary to the law of India, it couldn't also be contrary to the public policy of India. They are two separate things. Being separate, therefore, public policy of India, now construed as fundamental policy of Indian law, could not, therefore, have error of law apparent on the face of the record in it. So far, so good. So that was one restrictive aspect. The other was, a differentiation was made, not as clearly as I would have liked, between public interest and other interests. Now you could have, for example, governmental interest as opposed to public interest. You could also have governmental interest as part of public interest. You could have individual interest as part of public interest or purely individual interest. But the court didn't make these fine distinctions. It just went on to say that on the facts in that case, the Foreign Exchange Management Act dealt with the economy of the country. It therefore dealt with public interest. It was therefore part of the fundamental policy of Indian law. It also said enforcement of court orders is another important aspect of Indian law, therefore part of its fundamental policy. So far, so good. Then comes a challenge in the context of the domestic scenario. Because don't forget, the same language is used in section 34 as was used in section 48, borrowed from Article 5 of the New York Convention. So, for the first time, the Bombay High Court dealt with such a challenge. I must tell you, unfortunately, Justice Sri Krishna's judgment in the Bombay High Court was never brought to the notice of the Supreme Court in the Saw Pipes decision, which is so well known. And that judgment specifically stated that whatever was public policy of India, the words of India were added for the first time by this act, would mean exactly the same thing for a foreign award as it meant for a domestic award. And therefore, the so-called narrow interpretation was preferred. A year after that judgment, which was delivered in 2001, in 2002, we have this famous Saw Pipes decision. The Saw Pipes decision reasoned as follows. It did not open either the hydra head of interest of India or justice or morality. What it did was to add a fourth head. And the fourth head now became patent illegality. Now within this broad rubric fell three other things. First, 28(1) of the 1996 Act, in a completely different context, said that in a purely domestic arbitration between, let's say, two Indians, the two Indians obviously cannot contract out of the substantive law of India. They have to apply the law of India. But the court read that provision as meaning that since all awards made under this part are subject to the substantive law and have to conform to that substantive law, comes back the principle of error of law without any of the things like error apparent, for example, or on the face of the award or some document appended to it. So, any law now infringed would immediately cast the death knell of an award. So this opened the door very, very wide. Secondly, it said contrary again to a large number of judgments which said that the arbitrator ultimately may be bound by the terms of the contract, but ultimately it is his interpretation of the contract which should be preferred, unless it's something so absurd that the court has to interfere. It read section 28(3) of the Act to say now that since the arbitrator is bound by the terms of the contract, if the court says that the contract is X and the arbitrator says it is Y, again, out goes the award. So it opened really a huge floodgate. And in this country, awards started getting set aside much, much more than they should have. What was forgotten was Lord Mansfield's exhortation to a general who was given plenipotentiary powers, including judicial powers, when he went to Jamaica to rule it. He asked Lord Mansfield for his advice and said, what do I do when I have to judge cases? He said, do as your head and your heart dictate. By and large, you will be right, but see that you don't give reasons. Because the moment you give reasons, somebody will interfere with them and your award will be set at naught. Now, interestingly enough, the saw pipes regime, so to speak, continued for a decade here. And not only did it continue, its effect was felt in the foreign award area as well. Because in 2011, our court, in the Fulchand exports case, decided that what is good for a domestic award should also be good for a foreign award. And therefore, out goes the narrow view, in comes in the massive broad view. So that even foreign awards, when they had to be recognized and enforced here, had to conform to the drill of saw pipes. This fortunately was done away with in a recent judgment in Sri Lal Main, so that at least so far as the foreign awards are concerned, you go back to the old Renusagar position. But so far as the domestic position is concerned, one more Hydra head raised itself in a very recent judgment in Western Gecko. We thought that the fundamental policy of Indian law was now construed by Renusagar to mean X and nothing more. A very recent judgment of my court laid down that it meant three other things now. And the three other things were, one, an award could not be arbitrary. It had to conform to basic judicial standards. It couldn't be contrary to natural justice, point 2. And point 3, the administrative principle, once more, borrowing from administrative law, of the famous Wednesbury case, Lord Green's famous paragraph, that if you take something irrelevant into account, it is bad. If you do not take something relevant into account, equally your order is bad. And if no reasonable person could have passed the order, again it's bad. All this became part of fundamental policy of Indian law. Now with this massive broadening again, and don't forget, this would apply to the international scenario as well. The Law Commission has now delivered a report, and it is yet to be seen as to whether Parliament will accept it in its entirety, not accept it in its entirety. But we know one thing, that ultimately what they have done is to say that fundamental policy of Indian law cannot possibly go to merits. So that all these three tests go. And you restore the old Renusagar position. They have also recommended that any award that is contrary to the interest of India equally will go. The interest of India exception has been removed. And they have said that justice and morality now can no longer be something open-ended for yet another decision to say that something is unjust. But it must be the most basic notions of justice and morality, something that shocks your conscience. It must be something egregious for you to then say that an award should not be recognized and enforced. It is yet to be seen whether this is accepted or not accepted. And interestingly enough, it has reinstated the Chamse-Bharat principle. And this principle, it is reinstated only for the domestic arbitrations, not for international arbitrations, whether conducted abroad or in this country. We have yet to see whether this commission report, we hope that it will, Parliament in its next session, will at least apply its mind to it. And if it does so and passes it, there will be a great deal of stability brought back to this area of this troubled area of the law. One other interesting feature of our law has been the other problem which has plagued our jurists. Namely, what do we say about seat? We didn't give much of a thought about seat at all, because a seat has been likened to an exclusive jurisdiction clause. And early on we had a judgment in National Thermal Power Corporation versus Singer in 1992, before this act came in, under the old Foreign Awards Act. Now that act had a section 9B which said that arbitration agreements which were governed by Indian law were outside the scope of the Foreign Awards Act. The agreement that the court had to construe specifically had one particular clause for domestic arbitration and another for international arbitration. The domestic arbitration clause specified that the Indian Act 1940 will apply. The foreign arbitration clause said the ICC rules will apply. Given that, this court still said that since the substantive law of the contract is Indian, the law of the arbitration agreement will also be Indian, and therefore an award delivered abroad with the seat somewhere else would be a domestic award governed by the 1940 Act and not by the Foreign Award. This was done away with, fortunately for us, in the 1996 Act by enacting Section 51 in Part 2 and dropping Section 9B, so that one couldn't say that again. But despite that having been done, another problem arose in 2003. We had a situation where an award was to be delivered abroad, not yet delivered. The seat obviously was abroad. The ICC rules applied and the venue was Paris. The foreign party wanted to get interim orders against the Indian party in India, because if it succeeded ultimately, the Indian party might well do away with its assets or some such thing. So they wanted something in the nature of an attachment before judgment. And they were faced with this, that look, Part 1 applies only to domestic arbitrations. Section 9, which deals with interim orders, also applies only to domestic arbitration, and therefore out you go. In fact, that was the view of 5 high courts. But the Supreme Court stepped in and reversed. And reversed fundamentally on many grounds, but fundamentally on the ground that since this act really copied the UNCITRAL model law, it made a very significant omission in one section, in Section 2. And it said this part will apply where arbitration takes place in India, dropping the word only, where the place is India. So the court said the word only has been dropped. Since the word only has been dropped, we come back to this concurrent jurisdiction of the Singer era, and unless an agreement is so drafted that it expressly or otherwise by necessary implication does away with the Indian Act, even Part 1 will apply. And the logic of this decision was then applied in Venture Global's case in 2008 to say that a foreign award could be a domestic award at the same time. That actual reductio ad absurdum. Because a foreign award is separately defined in Section 44. A domestic award obviously is an award made in India. And they said, following this logic, that unless the agreement does not expressly or by necessary implication do away with the Indian Act, that foreign award can be tested 3 times over. Once in the country in which it is made, once under our Section 34, and then to recognize and enforce it by the other side under Section 48. Now all this, fortunately for us, was done away with by a 5-judge bench decision in 2012. But with a caveat. The caveat is this, that in the last paragraph, the bench then went on to say, we are declaring this as the law only prospectively. All arbitration agreements that were entered into prior to our judgment will be governed by the old law. Now this again, the Law Commission has sought to do away with by saying that not only should the agreement be before the judgment, but there should be some pending application. And unless there is a pending application, the law declared by the Constitution bench of 5 judges will operate. Another very interesting feature is that ultimately recent judgments of our court have made this differentiation between seat and venue and done it quite well. They referred to a number of English judgments, the famous Shashwa judgment, the Braze and Douane judgment, Naviera, CND, etc. And ultimately said that foreign arbitrations must now be regarded as seat-centric. And the Law Commission again has defined seat to mean the juridical seat, where in fact the arbitration is supposed to be enforced, as opposed to a venue, and taken steps to see that if the juridical seat happens to be in India, only then will Part 1 apply and not otherwise. That again is a salutary feature of the law, and we hope that Parliament passes at least these 2 important aspects of the Law Commission report, namely the public policy exception as well as the seat part. There are a number of other little things that they have done, including, as my friend Hiru said, tried to introduce time limits, tried to exhort arbitrators to go on day to day, tried to limit their fees, etc., etc. If all that passes muster, well and good. But ultimately, at the end of the day, the middle path is the real path that all of us should tread. And that middle path is that the rougher the justice that an arbitrator ultimately delivers by way of his award, the more will a court want to interfere. And that must never be forgotten. So institutional arbitration, which sees that the award is not only checked for flaws which are technical in nature but flaws on merits as well, would go a far way into ensuring that courts interfere as little as possible. Thank you very much.
That's